Hello everyone, I am Dr. Chitra Devi, Assistant Professor of Commerce, Professional Accounting. In this video, we are going to see a very important topic from the subject company law, that is Memorandum of Association. Let us get into the topic. Yes, first we'll get into the topic. First we know what are the documents, basic documents required for the company law, that is for a company to register. Before the promotion, they have to three basic legal documents are required. So what are the documents are required? The first one is Memorandum of Association, and the second one is Article of Association, and the third one is Prospectus. So these are the three basic legal documents issued by a company. The next one, what is Memorandum of Association? While incorporating the company at the time of promotion, with the register, what are the registration promotional activities they are going to do? With an application, they have to submit the Memorandum of Association. With the application, they have to insert that Memorandum of Association copy also with the registrar company. So what is Memorandum of Association? It is a basic legal document of the company. Every company should maintain this Memorandum of Association because it is a basic documents of the company. And we can say it is also known as the charter of the company because all the Memorandum of Association of the company mention its objective. What is the objective of the company? For what is the main objective means? For what purpose the company is established or incorporated. So the objective should be clearly mentioned in the Memorandum of Association. And it is also external, that is it is also mentioned that what are the limits of the company. The company should do this alone and company should not this. What are the things they should not do and what are the things they should do. So it sets the limits of the company what they have to do. So these are the basic main information they have mentioned in the Memorandum of Association. And we can say it is the constitution of the company also. So these are the Memorandum of Association. Let us discuss what is the definition of a Memorandum of Association. Yes, under Article 122 that the Companies Act 1956, they have defined Memorandum of Association if a company is originally framed for time to time, change in provisions of any previous Companies Act or other ordinance, because they have to register as per the Companies Act 1956 or other relevant acts also, because the latest Act 2013 and 2020 also, they may register under the any act. Yes, what are the requirements of Memorandum of Association? Yes, the Memorandum of Association form must be in the printed form. While you are attaching with the registered application, it should also be inserted with that. So it should be a printed copy and it should be divided into different paragraphs. So it should be accordingly the paragraph should be numbered in serial numbers. They have to keep the serial numbers in consecutive orders in the paragraph. Okay. And what are the subscribers are included? What are the members are included? They have to mention their names. How many members are included? In case of private company, one minimum of 2 members, that is minimum of 2 directors should be included. And in case of public limited company, minimum of 7 members should be included. We can say them as a subscriber. So their name also should be present. Their name, what are their address, what is their address, everything should be mentioned in the Memorandum of Association. And the subscriber should be signed with the evidence of the witness. Every subscriber should presence with the help of help of the witness, everyone, because in case of a private limited company, there will be 2 directors. So every director, because 2 directors, for 2 directors, we need 2 witnesses. And for public limited company, 7 directors. So for 7 directors, we need 7 witnesses. So everybody should be present in the presence of at least 1 witness only. The subscriber must be signed. So after that, it should be stamped. So these are the basic requirements of Memorandum of Association. Yes, next, what are the contents should be included in the Memorandum of Association? So it should be classified under different classes. So the first one is name class and the second one is registered class, third one is capital and the fourth one is liability and the fifth one is subjective. So these are the different classes, or we can say it is a contents also. It must be present in the Memorandum of Association. Let me see one by one. First one is name class. Name class is prescribed in under section 4 and subsection 1A. Yes, companies, what are the names should the company should keep and what should not keep? Yes, the company should not keep the name like king or queen or some other any related names, kingdom or queen related names. They should not keep any names related to that. And the companies also do not use the word as a name related to the state, central, union, corporation, like some other words also they cannot use. So they can use only the word limited in case of public limited company after that name, because suffix they have to include the word limited. In case of private limited company, they can use the word private limited in the after the name of the company, that is suffix they have to use the word private limited. In case of one person company means they can use the term one person company after their name, that is suffix they have to insert. So these are the only conditions they have mentioned in the name class. After that only, that is publication of name. The name should be after kept the name, that is the company has been incorporated, the name has been registered. After the registration of the name, the registered office, they have to keep their name board in the outside of the registered office. Their names should be printed in the format, because we can also keep the paintings with the names. We can paint the names or we can attach any board or lamination board. We can keep any other outside. It should be kept in the registered office. That is only. So name class kept under section 4.1a. The second one is registered office class. It is mentioned under section 4.1b. The second one is registered office. So what do you mean by the registered office means every registered company have some registered office where it is located. So it is mentioned what is the state and where the registered office going to be situated. In which state, in which place the registered company is going to be situated. That is only mentioned in the registered clause. So the registered company, if they have mentioned in the particular state, the particular place, it is the permanent address of the company. Like we have a resident, we have a separate address for that our resident. Like also the company also have some permanent address. Which company, what is the permanent address means, what is the where the registered company is situated, that is the permanent address of the company. So they can use the companies, that is residence company address for many purposes. For example, if the company want to communicate with their clients or some other shareholders, they can communicate with these address only. The registered address only they can use for the all communication purpose, for the all mail purpose. And we can say it is a specified company's letterhead. For each company they have separate letterheads and bill books, everything they have. So in the bill books and the letterhead, they have mentioned their registered company address at the top of the page. So this is only mentioned regarding the record class. The next one is object class. Already we have mentioned the object of the memorandum of association. In the memorandum of association, the object should be clearly mentioned. What is the objective of the company? For which objective the company is incorporated. So it should be mentioned in this object clause. So it comes under section 4.1c. So what is the main objective of the company? Why it is established? In what extent it can go? In what extent it should not go? What is the limit of the company? What is the main purpose of objective is mentioned means, if the shareholders wants to know whether the company is, what purpose the company is going to use their money, because they are going to invest in the particular company. So they want to know for what purpose the company is going to use. So the shareholders can know from the memorandum of association for what purpose the company is going to use the money, where the company is going to invest the money. So through the object class we can we can definitely know the objective of the organization. As the company, what is the objective? That objective alone the company can go. Beyond the objective the company cannot go. So the cost of creating the capacity is high. Yes, the next one is liability class. So one of the main characteristic of the company is limited. The liability of the shareholders are limited. Limited means there will be two types of limited by shares and the limited by guarantee. In case of limited by shares means if the shareholders want to buy 10 shares with the value of 10 rupees, but they have paid only for 5 shares. Remaining 5 shares they did not paid. So for that only they have the liability. So they have the liability to pay for only the unpaid shares. How many unpaid shares means for that only they have the liability. So, and liability by guarantee. In how much guarantee they have mentioned in their agreement, as per the guarantee they have to take their liability. So limited by shares and also limited by guarantee. For unlimited companies the liability clause is omitted. For limited companies only limited by shares and limited by companies. For unlimited companies the liability is omitted. The next one is capital clause, that is section 4(1)(e). Yes, capital is one of the important investment of the company. The shareholders are going to invest in the particular company. Okay, so the company must mention in the capital clause how much capital they are going to raise. You can say it is an authorized capital. So how much authorized capital they are going to raise? The company can raise the capital by issue of shares, debentures, etc. In the case of shares means how many equity shares and how many preference shares they are going to issue. And the nominal value of the share also they have to mention. If the company want to issue 100 shares, that is 100 equity shares with the value of 10 rupee means they have to mention how many shares, how much is the nominal value of the share. So everything should be mentioned, how many preference shares and how much debentures they are going to issue. So everything should be mentioned in this object clause. Yes, last one is nomination or succession clause. It is only applicable to the one-person company. It is not applicable for the that is private or public limited company. Why means if one director is not available, we have other directors to take the responsibility. But in case of one-person company, only the one person is the liable. So in case of death of the person or proprietor or the owner, so who is the other person to take the in charge of the company? So he is the person called the nominee. So in the event of the death of the subscriber, the prior written consent of the nominee should be required. So there will be a separate form number INC 3. So nomination in form number INC 2, they have to submit to the registrar and they have to undertake the company. So these are the different contents, that is classes we have to mention in the memorandum of association. The first one is name and second one is registered office, third one is object and fourth one is liability and last one is nomination. Nomination is only applicable for one person company. Thank you.